What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is still Friday, January 24th. We're going to finish up the recap from yesterday's hearing in the Bryan Kohberger case. I still need to watch the hearing from today and get caught up on that. So I'll have that out at some point this weekend. We left off after we finished the arguments about suppressing the IGG evidence. We pick back up on the argument for the Franks hearing. And the state says on December 23rd, it's a few days prior to when Bryan's name came up first, but you wouldn't know that from reading the probable cause affidavit. It's omitted. Prior to that, the lead detective in the case hadn't heard of Bryan Kohberger and he wasn't on their radar. That should be in the report. But it was the FBI's work. Going into databases they shouldn't have gone to and doing things in secret is the only way a name was produced. Had the magistrate judge heard about that before signing the probable cause affidavit, that might have given the judge caution or made the judge wonder what else they're doing behind the scenes. We don't know what they did. There was no record kept, none produced, and it was all done behind closed doors. We only know his name because of what was being done behind closed doors. What else were they doing? The affidavits are a group effort. If the court has the initial exhibits, the court will know this was the same FBI that violated their own policy in identifying someone. The first warrant with anything related to Kohberger is 48 hours worth of records from AT&T. The affidavit also says the roommate saw and heard things within her house, but what's in the affidavit is lacking in details, it's wrong, and false in many places. For example, it says this person stated she went to sleep on the second floor. She was woken up with what sounded like a victim playing with a dog on the third floor, and she thought she heard a victim saying something. But that's not what she said. She was sure she heard a victim go up the stairs and come running down, but that's not in the affidavit. It's repeated in the same interview a couple of times. The affidavit waters down what was said. They knew what she said about someone running up and down the stairs. We know that person was murdered in her bed and never got up, but they never told the magistrate that. This witness has claimed to have memory problems, isn't sure what she heard or saw was real or if it was all a dream. The witness said she had too much to drink and couldn't remember. That was withheld from the magistrate, and the magistrate would need to know about credibility issues. The state moves on to suspect vehicle number 1. Investigators trails a path of pieced together cameras, but they don't tell the magistrate the cameras close to the house, you can't tell what kind of car it is. Their expert can't make an identification. Another issue is the year of the car. The magistrate doesn't hear it's not following a consistent trail. It appears one time, and they took several videos from the area and say it's the same car. The ID of the car was from an FBI agent, a 2011 to 2013 Elantra. Law enforcement relied on that, and the be on the lookout was for a 2011 to 2013 Elantra. They misled the magistrate that they have a clear view of this car making the loop, but it's pieced together. In the affidavit, they talk about the dog barking and say something is happening in this house. They picked out a time when something probably happened, and they don't tell the magistrate. The dog continues to bark long after the car left the area. The dog was found the next day, and the dog hadn't tracked any blood. There was no blood on the dog, and it's sitting in an open room with an open door. The magistrate didn't hear about that. The investigators talk about 2 traffic stops, and this is where the lack of the IGG is important. 2 random stops months ago in populated areas with a lot of college kids doesn't add to the investigation, but is put in there to bolster this investigation to say it's something it wasn't. The worst of that is after the bolo for the 2011 to 2013 Elantra goes out, they find one that's at Bryan's apartment complex, but it's a 2015, and they didn't do anything with it. On December 20th, the lead detective got a hold of campus police and says, "Oh, you called this in?" He didn't know about that before, but it's just stacked in there like it creates probable cause when it doesn't. You have law enforcement willing to violate their own policy. You're not being told the full story about what a witness says, and you're being led down the path to say this was a real investigation when it wasn't. You don't find probable cause. The judge says if he finds the IGG was not constitutionally obtained, doesn't it just add to the probable cause? If it had been disclosed, it would be more reason to suspect Kohberger. And the defense says no. Think about how that would read. This is a new technology, and we've identified someone. We didn't keep any of our documents, even though the Department of Justice says we have to. Even though we can't go to certain databases, we ignored it. You should find it unconstitutional, and if not, it should be a separate analysis. You're looking at integrity of signing off on a search warrant. If you know the rules don't matter, you're going to hide what you do, and that doesn't matter. There's not a lot to rely on. When they came to the magistrate and said, we want to search this house because we have a confidential informant who gave a lead and we think we will find evidence of a crime, but we can't trust this informant because they won't tell us how they know or what means they used. They threw away the metadata. And the informant maybe has integrity issues and the judge isn't going to sign off. I'll tell you what I didn't know before my informant told me, and these things don't add up anyway. There's no judge, in my view, who would find probable cause because someone got stopped months before for a seatbelt violation. The judge speaks up and says it was to find out what kind of car he drove, and also he had no license plate on it. It's not to say this car was connected to the homicide. It was a car of interest, and the defendant was driving it. The defense says, well, let's talk about the license plate. It was testified to today that you couldn't see it. That was extra after the IGG stuff. There was no video collected from WSU, no communication with officers at the university before, but the judge says he's not tracking why that matters. And she says it wasn't a real investigation. It was just put in there to make it look like an investigation happened. Don't look here. This is ugly. This is dirty. It's not real. That is why it was put in the probable cause affidavit like that. But it doesn't end there. The warrant isn't good. There's false information, and there was information withheld from the magistrate judge. The second warrant that was obtained was for AT&T. An hour after the first search warrant comes in, and they say they have all of it analyzed, and they need 6 months of records. And they do acknowledge his phone isn't contained in the geofence. Going back to that first warrant at 2:42 a.m., WSU cameras, which they look at after the IGG identification, they see a white Elantra leaving the apartment complex. Then, when they look at the phone records, it becomes 2:44 a.m. and say Bryan's leaving his apartment. The place near Bishop Boulevard where you would turn to go to Moscow is inconsistent with 2:42 a.m. They don't say it can't be the right Elantra running around that night because it's seen at 2:44 a.m. They want to keep it in because they want the car positioned to be going towards Moscow for the magistrate. They report the phone stops reporting to the network at 2:47 a.m. That's not right. Their cell phone expert report said it stopped reporting after 2:54 a.m. Don't get caught up thinking 7 minutes doesn't matter here. We're talking about two towns that are fairly close, and the way the car is pointed when they go off the network matters a lot. That is not corrected in the affidavits, and that's what's exculpatory to Bryan. The direction the car is pointed when the car stops reporting. They took a time 7 minutes before the phone stops reporting to create a false narrative to the magistrate to find probable cause. The second AT&T warrant comes, then you have warrants for his arrest, DNA samples to be taken, a search of his home, car, and his parents' house. And what's added to that set of affidavits is Kohberger's phone using a tower that provides service to the crime scene. In the cast experts' draft report and file report, they don't match. There's different dates and times. It's misleading when you say the cell tower that services the crime scene. Moscow has two towers, and from the records, you see handoffs and where the car is going. If it's parked looking at a particular place, Based on those records, they knew Bryan wasn't around that residence, he wasn't parked, he didn't stop, and he did not have his phone stationary. They knew it wasn't happening, but put it in there to make that connection. They knew it was incorrect. They also changed it quite a bit. They did drive testing, data was coming in, and they knew it was untrue. The magistrate was relying on a witness who has been interviewed several times and has memory problems, and the magistrate doesn't know that. You have this false narrative that looks like stalking, and it's not true. It's an outright lie to the magistrate when you take that context out. Our proffer shows the date changes. Defense experts will talk about the patterns of handoff and how that paragraph was misleading to the judge. He did go to Moscow, but he didn't go to the crime scene, and the phone records show that. The warrants that come later between February and April, Amazon, Google, Apple, here's what's left out of those warrants. Bryan gets arrested, search warrants take place, his car was searched 3 times, and there is no connection between him and any of the residents of the crime scene. The judge asks if she has transitioned to talking about the warrants after the arrest, and then he points out at the time of the arrest, they did have a direct DNA connection. He said there's other evidence the defense can claim is exculpatory in their case or on cross-exam at trial, and then asked the defense, isn't the DNA enough probable cause to support any of it from there? She said there's a lack of DNA in his car and apartment and also on the victims. The judge says even if disclosed, how does that preclude a finding of probable cause when there is a DNA match between the DNA on the knife sheath and Bryan? Isn't that probable cause every day and twice on Sunday? And the defense says not in this context because of the IgG work. That's the question that'll be before a jury. What does a knife sheath at the scene mean? The judge says, well, they were killed with a knife probably means a lot. She says it might be a lot. And the judge says probable cause isn't proof beyond a reasonable doubt standard. It's probable cause to think he might have done it. And the judge says he's not sure how that direct DNA connection on a sheath found on or near one victim doesn't close the book on any probable cause after that. She says it doesn't. There's other factual information the magistrate should have known, and there's a lot of pause at a probable cause level. The judge says, how does no DNA in his car or apartment preclude probable cause when there's a direct DNA match? When a magistrate is looking at this and they have direct DNA evidence from an object likely associated with a murder weapon, I've yet to meet a magistrate who wouldn't find that probable cause. The defense brings up the car location and says there's 13 minutes between seeing the car and then seeing it again. If you have a car that's searched and taken apart, the brakes are taken apart, the gear shift is sprayed with luminol and there's no blood, the magistrate should have known, and that's exculpatory. The judge says it could be, but how would a DNA connection have a magistrate say there's no probable cause when you couldn't find no other connection to forensic evidence, when there's other things in the affidavit that could explain that, like coverings for clothes and gloves that could be put in a bag real quick on the way out? That was in one of the affidavits, but when you get to where they have the evidentiary DNA, it seems it's an uphill battle to say that's not probable cause at that point. The defense says you should never get to that question because you should find AT&T 1 and 2 were terrible. There's no probable cause for those, and they build on those. If the magistrate had been told there's an unknown male who they label B, whose blood is in the house on the handrail, that might have made a difference to the judge. Maybe a sheath could be carried into the house and there's blood in the house that's not the same. Maybe that matters, and the car with no DNA connection matters more. The judge says, I'm not sure it matters for probable cause. The defense says she doesn't think probable cause is a vacuum. It's not one thing, and she hopes it's not. I hope there has to be more. When you have one thing, it's the same as another thing. The judge says about the DNA on the handrail, maybe there's someone else involved. If you assume the blood was related to the victims and not some earlier event in the house. But she said that's what the magistrate needed to know. We have the sheath, but the other things, other explanations. This magistrate wasn't given a chance to ask that. She wasn't told about unknown male B and unknown male D blood on a glove outside the house. Could it mean more than one person? Or could it mean it's not Bryan because there's no blood in his car and there was 13 minutes to commit the murders? The judge says, but his DNA is still on the knife sheath, and that's the problem for probable cause purposes. The defense says, I can see if that's all she's told, why she would find probable cause. What she wasn't told creates a context around it. The purpose of a Franks hearing is this very question. The judge says once you have a direct DNA tied to the defendant for the purpose of probable cause, not conviction, you haven't explained why any magistrate wouldn't find probable cause as to Bryan. Now, other people may need to be investigated further, but that doesn't diminish Bryan's DNA on the sheath. She said the biggest question is, how did the sheath get there? You can have DNA on an object at a scene and you don't find probable cause because there's more questions than there are answers. And this one thing doesn't look so big when there's no context around it. With unknown male B and D, there's a lot of context there. The question of how is that there is the question the magistrate should have had. She mentions the witness who says things that couldn't be true, admitted she really didn't know anything, so you take that out. You don't know how the sheath got there. There's no blood on the wall from Bryan. The item shouldn't be a question when there's other male DNA in the house and lack of other DNA connections, and no connections between the victim and Bryan based on cell phone records and social media. The magistrate wasn't aware of all those factors when deciding on probable cause. The judge says for Frank's purposes, you're implying the police intentionally didn't tell the magistrate the lack of evidence in other places. She said we have omissions in this case and false statements. And the state gets up for their turn and says you have to make two different inquiries into the claims. Has the defense showed the exhibits attached to the statements for probable cause that were the basis for the search warrant? Were there deliberate false statements and omissions? It's a high hurdle for them to jump over. If you can say yes, then and only then should we move on. Does that statement diminish the probable cause finding? When the answer is yes to both, then you consider getting a Franks hearing. A serious allegation that law enforcement lied to the magistrate to secure the warrant, the statements have to be deliberate and false. Franks isn't implicated by mistakes, errors, or even negligence. The defense is alleging law enforcement lied to get the probable cause. They failed. Law enforcement submitted the probable cause affidavit based on the information they had available to them at the time. That's how it's supposed to work, and that's how it did. They allege 13 separate areas where they say there's a Franks violation. The idea of attacking Exhibit A. It's law enforcement statements that lay out the facts known to them related to the probable cause to get a search warrant. This was 20 pages of facts for the judge to review. That was relied on for multiple warrants. You heard from Detective Payne earlier. Multiple officers from multiple agencies were involved. They did briefings 2 times a day for weeks at a time, with all lead investigators in the same room receiving the same information. This information was put into Exhibit A as a probable cause affidavit for a search warrant. A working document like this is with the most up-to-date information, and that's the best way to ensure the magistrate was getting accurate information. The judge asked, what do I do if the affidavit is attached to Detective A's submission? If there's a material reckless statement in there, but Detective A isn't the one who made it, it was someone else on the team. How does that affect the Franks analysis to the affidavit submitted by Detective A? The state says Detective A would have to have reason to know it was a materially reckless statement made by Detective B. The judge says even if the person who made the statement that's going into the group affidavit, which will make its way to the magistrate, the state says that would be an issue, but that's not what happened here. No officer can submit a statement that they know will go to a magistrate and do so recklessly. If they do, the court should take issue with that, but the group effort and cooperation is allowed. We have several Idaho cases that support this, and she cites cases As far as this being a multi agency investigation, the judge was put on notice that this was the case. Each one told the magistrate that Officer A, B, or C is being assisted by the Idaho State Police and the FBI, and that was in the document. It's clear where the sources of the information was coming from. One department says AT&T indicated that Bryan was near the King Road residence. This claim is signed by Detective Laker. This officer didn't claim to do the cast work. It says, I consulted with a certified agent that does cast work. It goes on to tell all their experience with cast. One detective said he was able to tell by that investigator's work and through his own experience, he could determine that Bryan was near that residence. She says, we differ on a few factual issues because I think there's 3 towers that service Moscow. And the judge interrupts and says, that concerns me. Where in the record is that currently, aside from anything you filed since they filed for a Frank's motion? If you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. I'm looking at the proffer from the defense without evidence by the state. So I get concerned when you tell me things that aren't part of the evidence. The state says they can move on from the towers. The phone was in the area of the tower that serves the crime scene. None of that has any validity on the search warrant. They move on to eyewitness statements. The defense claims the magistrate wasn't informed. The roommate told law enforcement when shown a photo of Bryan that she didn't recognize the defendant. But reading the probable cause affidavit, it's clear she's not going to recognize him. The judge asked what was the statement, and the state said she consistently gave the same set of facts. The judge says, why is it important the magistrate knows this? Does it establish a timeline of the murder, who the perpetrator is? The state says the general description of who she saw in the residence at the time these murders occurred. The general description was consistent in all of her interviews. She saw someone in a black mask with a portion of their face visible. It was a male who was white. It was a voice she didn't know. He had a slim, lean build, and he was taller than her, and she is 5'8". That's what's important, is the general description of the suspect, and it didn't change. The timeline matched the vehicles seen on surveillance coming into the area and leaves, as well as text messages relaying what she's observing in the same time period. Even if the state is wrong and there's exculpatory evidence to her statements, you can take it all out and the magistrate would still have probable cause. The second issue with the roommate is other statements she gives. When she says she isn't sure about what she saw being real, a magistrate should know about it. The simple answer is investigators knew what she saw was real and not a dream because they found evidence the next morning that supported that. That didn't need to be excluded because it's not exculpatory. Next, they attack the vehicle identification. And this was 5 pages of the probable cause affidavit based on an expert review who told investigators the suspect vehicle was an Elantra and there was a discussion of the year range. The specialist said it was between a 2011 and 2016. Detective Payne relied on his expertise and included that in his probable cause affidavit. Regarding the surveillance video of the car, they take issue with that because they say that can't be surveillance of the Elantra because it was caught on video 0.3 miles from the crime scene, about 3 minutes right before we see the suspect vehicle enter the area of the crime scene. 0.3 miles in 3 minutes is about the time it would take the vehicle to travel to the area of the crime scene. They say it can't be the right video because the surveillance up the street should have caught it on video too. We know that's not true, and that was submitted to the court. The judge asks when that was submitted, and she said through the defense response. He said, I was afraid you'd say that, but she said it's been given to the defense in the discovery process. It's since been confirmed. Special Agent Hill confirmed and discovered this, that the surveillance video set up to capture motion would not have captured the corner the defense says must have been captured. But at the end of the day, the speculation about the route of travel isn't a basis for a Frank's hearing. They haven't made a sufficient proffer for you to do that. The judge asked, can you tell from the affidavit what cameras and shots were relied upon to make that identification? She says, I don't know that you need it to. He says, my question is if the affidavit describes the specific shots to make the identification. She says, no, it takes several videos which were reviewed and images turned over to a car specialist who then made the determination. But we didn't give every still photo or video to the magistrate, nor did we need to. They move on to the IGG issue, and the state asks, is that a basis for a Frank's hearing? You heard that law enforcement received this and made a strategic decision not to include it because it was only a tip and they needed to develop probable cause separately, which they did. You've already hit the nail on the head with your questioning to the defense about this question about using the IGG. It's only inculpatory. The non-reliance on the IGG, it doesn't diminish probable cause. The IGG information was confirmed through the STR DNA testing. I don't see how the IGG testing is exculpatory. Regarding the dog barking and them saying the magistrate should have been informed that the dog barked 25 to 30 minutes after, this is a reach for me. I don't know how this is exculpatory and it doesn't diminish probable cause. But back to the cell phones. This proffer is their opinion of the evidence and it doesn't warrant a Frank's hearing. Our expert has their opinion and the defense disagrees. That's a dispute that should be heard at trial, but it doesn't give you the basis to grant a Frank's hearing. The next issue is the bloody footprint found outside the roommate's bedroom, and the inclusion of this was misleading. There's nothing misleading about the statement, which is the investigator found a latent shoe print, which came back with a presumptive positive blood test. They let the judge know it was outside the roommate's bedroom and was consistent with her statements. The defense's opinion about where this shoe print should have been located versus where it was doesn't rise to the level of a Frank's. Our case doesn't hinge on the identification of the shoe print or the probable cause affidavit. There was sufficient probable cause without that information. The judge asked if the cast agent knows there was a misrepresentation in the report. The state says, I don't think there's proof the cast agent submitted false information. There's a difference in the handoffs of 7 minutes. I don't think it's material. But the judge asks if the car is going in a different direction than what your affidavit says. Isn't that material? The state says it would be if it was found to be outside of Pullman. This assumption is that cars can't change direction of travel. You're assuming the same cell phone which was turned off isn't tied to the evidence, but we have information to believe a white sedan tied to Bryan is seen on surveillance. We're talking about surveillance at 2:50 a.m., just a little over an hour before the murders occurred. I don't follow the logic that in an hour and 10 minutes, Bryan couldn't have traveled to Moscow whether the car was pointed in a different direction before or not. If it was exculpatory or false, it wasn't, but let's say it was. The magistrate still had enough information before her to grant probable cause, and we still don't get to a Frank's hearing, even if you want to make that leap. As far as grand jury subpoenas, their desire to see the grand jury subpoenas is not a basis for a Frank's hearing. There's nothing that was obtained in violation of Bryan's constitutional rights. They say they needed to know the scope, but we don't know why the magistrate would need to know that. This is an attempt for the defense to obtain these grand jury subpoenas. As for the lack of connection, this has no bearing on the probable cause affidavit. Investigators relayed what they knew at the time of the application of most of the warrants, the evidence taken from Bryan, and his car was still being reviewed. We don't know if there was a connection. Apple, YouTube, Instagram, PayPal, and Microsoft fell out of that. The car was recovered 6 weeks after the homicides. If the court believes law enforcement shouldn't have included this, it's not enough to outweigh the balance of what did establish probable cause. The defendant has failed to establish a false statement or omission that without which the magistrate would not have found probable cause. At this point, the defense gets back up. She says, I'm curious about the new police report that was talked about. I don't see it. The judge says that wouldn't be part of the analysis if you've met your showing to have a Franks hearing. The defense says that's good because it came after her Franks briefing and she hasn't seen it yet. As far as the grand jury, they used the returns from the grand jury subpoenas to obtain information. And we don't have those. And we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. The judge asked if they're referring to Amazon, and she said yes, it's problematic. They say you can't have it, but we didn't do anything wrong. We should have a Franks hearing to explore what that's about. The judge asks about the omission in the Amazon warrant. The defense says the FBI used the grand jury system and got this information outside the warrant process, but for some reason, we have to come get a warrant. It makes me really suspicious. The judge says, as to the Franks perspective, the question is, was there material reckless misstatements? She said it was relied upon to get the warrant. The judge said it was disclosed to the magistrate. This was a result of what was disclosed to the grand jury. What did they fail to disclose? The defense says the parameters around the grand jury subpoena. They go back to talking about the 7-minute time gap there, and the defense says there's a lot that wasn't disclosed to the magistrate. You heard earlier, there were hours of meetings and the decision for keeping certain things secret. I think we've satisfied the prongs of deliberate and intentional withholding from the magistrate or deliberate false statements on those areas. As far as the roommate's credibility, that was relied on and it appears in the affidavits. It's relied on after Bryan was identified to say he has bushy eyebrows. The affidavit for the footprint, it's a misleading statement. It's at the very edge of the door. It's one footprint and it's not seen throughout the house. To act like it bolsters the witness is important. The first interview, the issue was if one of the victims ran down the stairs. She didn't say it once. She said it 4 times in the first interview and it couldn't have happened. That was withheld from the magistrate. The roommate had memory issues. There were 2 references to not remembering, and then again a few days later, along with the roommate being drunk. She said, I don't know if it was a dream or if it was real, but what I think I heard was someone crying in the bathroom. This was brushed over and not given to the magistrate, and that's important when that person is relied on in the investigation. As far as the car, the way it's laid out would cause one to think the car was identified by the video near the crime scene, but it's not. It's piecing together the other videos to come up with something. The judge asked, was that the evidence they relied on from Ridge Road? She said, you can see that in the emails between agencies and say, we finally got a good one, which was the Ridge Road photo. And that's the only one you can use to make a positive identification of the car. He asked the state, where is that in the record? She says that it's in discovery, but he asks about their motion. It's just the photo and not the information that ties it to Ridge Road. The state said it ties to their argument, but she doesn't have anything from law enforcement saying it was that, and she would love to know more about that. The judge says that's not the standard, and she said she would refer the court to email communications and the photos in their Franks motion. As far as the IGG, the state reminds the court that doesn't identify a person, it shows a family group. And investigations can happen from there, but nothing happened until the IGG happened in this case behind the scenes and in the closet. She says that brings me to talk about the court needing to look at the entire picture. It's a long and complicated case. You have law enforcement meeting, and you also have the FBI sprinkled in. You heard about things today that are secret and not being talked about. A partial photo was decided on that left out a lot of information and false statements to the magistrate to get probable cause to get that first AT&T search warrant. The officers went back and forth talking about what statements should be used. Statements were changed, and the decision was to leave the witness statements in as they were. And even after several interviews, they knew they were incorrect. They built a false investigation and leave out the secret IGG part. They didn't want anyone to review their work and see if they did everything right. Probable cause doesn't get determined by one little thing without context, especially when there's omitted information. That's why we're asking for a Frank's hearing. There has to be integrity in the warrant process because there is a lot of power to go to a magistrate without us, meaning the defense, being able to cross examine. And that's a lot of danger to leave little things out here and add more things here and go get a warrant. This is a massive amount of information. You have 1,000 pages, meaning the judge. There's a lot going on here, and we ask for a Frank's hearing to explore this. That was the end of yesterday's hearing. It can get a little confusing because there are some things we don't know the context to, but I really wanted to thoroughly cover that part because there's some interesting stuff in there. I still need to watch today's hearing, recap that, and put it out at some point, maybe later tonight or first thing tomorrow. I'm not sure yet. Then I also need to go back and watch the hearing from the Corey Richens case from yesterday, update you guys on that. So we'll probably do that at the beginning of next week. And I just want to say, I know that there are a lot of people competing for your time. I really appreciate you guys choosing to spend some of your time with me. It really means a lot. I love what I do. So thank you guys for allowing me the opportunity to keep doing what I love. All right, that's it, guys. I hope you have a good rest of your Friday afternoon, and we will see you soon.